So I remember we had a quite wonderful discussions, not just about AI, but also we went quite deep into the legal topics, including jurisprudence or finding law, including natural law system or legal positivism. So which is quite genuine legal topics, even to law school students. And I was very much impressed that you were also quite interested in that topic and were understanding that frame and topics. Yes, I was very much impressed. So as it has been previously announced, today's topic will be AI ethics and law in healthcare. So basically, in Korean situations and also the global, how to say, situations. And the basic contents will be presented by Bo-Hyung Lee, maybe around in 30 minutes. And then we will move on to Q&A sessions and discussions, and we will get together again. So, Bo-Hyung Lee, so nice to meet you again.
Nice to meet you again.
So, are you prepared to your wonderful presentations?
Yeah, I'm not sure it is wonderful, but I prepared.
Yeah, I can see that you are prepared. So, yeah, let's move on.
Okay. First, before starting, I want to share my transferring PP presentation. So can I share?
Sure.
Okay. Because I know that many people in this course are foreigners, so I transfer some words in our presentation. So I'm not sure it is proper for those students, but yeah, I I really hope you join this presentation. Okay.
Okay. So before jumping into the topics,
Okay.
how about kind of introducing yourself once again? So your educational and career background, and
Okay.
how come you are interested in this topic of healthcare regulations, including your PhD dissertation.
Okay. First of all, thank you for opportunity to speak this kind of presentation. So thank you for Professor Hall. And my undergraduate major is biology and psychology, philosophy and business. And after undergraduate, and I went to law school in SNU, and at that time I met my wonderful professor Song Ko, and I did study about regulation and other administrative law, something like that. And after a graduate law school, I want to study more about this regulation and administrative law. And because of my undergraduate major is biology, so I want to integrate my undergraduate major and law. So after graduation, I uh, I I did study about regulation about healthcare, and now I do some process about making doctor thesis, so about digital healthcare in regulation. So I want to share my insight, or I want to share my thinking about this regulation system in Korea in healthcare. So a part of my doctor thesis is kind of AI. So I want to share my thinking about AI ethics and law in healthcare, focusing on domestic law. Okay, I think it is enough?
Yeah, I think it's wonderful.
Okay, then shall we start? Yep. Okay. Before starting, this is quite a long presentation, so I want to share your opinion about this healthcare. So how your guys making your assignment in healthcare? So please raise your hand. Did you make your assignment about healthcare? Yeah. Okay. So I want to ask you that what is the healthcare AI healthcare? What is the AI healthcare, and why we need regulation in AI healthcare? So I want to ask you in randomly. Is it okay? So I think Soyeon Kim's smile is quite good. So I want to ask you that what is the healthcare and why do we need the regulation in AI healthcare?
Can you hear me?
Yeah.
Yeah. I mean, I am majoring in consumer science, so I have not much knowledge about healthcare stuff. But I think when I hear the word healthcare, it sounds for me like I go to hospitals to check my health status and see if whether I have any problems in my health. And all the systems and all the devices are regarding those caring my health is healthcare for me. And
Right.
because of that, when AI comes to this domain of healthcare, it is really important because it is related to people's lives. And if it is not regulated properly, then it will harm people severely. That's why I think that's why we need regulations in this field.
Okay. Then how do you feel about the standard of healthcare? It is too high or low? Just your
You mean current regulation?
Yeah, right.
For me, I think it can depend on the situations and what kind of devices they are. Because my team studies WebSEP system, which is like it's like taking a picture of your jaw and your face bones and stuff like that. And actually, it's just assists doctors by providing these pictures. So when you regulate those things, I think the regulation doesn't have to be that harsh or severe. But if this healthcare system is something like I don't know, maybe if it is something like that machines that examines the cancer or something, it needs really a lot more intentions, and it should be regulated with much more higher levels, I think.
Okay. Thank you for your
I
sharing
think
your
it depends, yeah.
Yeah, thank you for sharing your opinion. I think quite good. So, like Soyeon Kim said, we have to make some concept. So we make some concept and status of healthcare in healthcare AI in Korean, and for that, for making that, we refer about the foreign healthcare system, healthcare AI system. So, the first of all, I will make some concept, and second of all, I will introduce domestic and foreign healthcare AI regulation and policy trends, and lastly, I will make some implication for this topic. Okay. Okay. As Soyeon Kim said, it is kind of trend of AI utilization in healthcare industry. So we should make some definition. So there is no general definition of healthcare AI, but I find some definition in some data. So in that, technology developed to use human level intelligence to diagnose, predict, and treat disease with personalized treatments. And it has a merits because the AI healthcare may rapid, accurate diagnosis and treatment, consistent individualized prediction and prevention of customized disease, and measurement without time and space constraints, medical treatment, etc. So in healthcare AI, we can recognize that healthcare AI covered all of things in medical or healthcare system. And using AI, what is AI in healthcare? So some GBSA said the type of healthcare AI is kind of deep learning, recognition of recording, something like that. So robotics and digital personal, yeah, and machine learning, something like that. So we have many kinds of AI in healthcare. So, but as I mentioned before, we do not have general definition in healthcare AI, and we do not have the classification in general, a general classification in a healthcare AI. So many people make some concept and make some classification because and no one knows what is a healthcare AI and what is the exact classification of that. So the quite popular person in Korea, like Yoon Suk Choi, is a doctor about healthcare, digital healthcare. He makes some classification of AI like that. As you can see in this graph, he makes some classification like medical device and digital healthcare is different, and the middle of the two, we can see the medical AI like Watson, IDX, Lunit, Puno, and Jira Medical. So I think we can focus on medical AI intelligence, medical AI in this graph. So the middle of the blue circle, as you can see. So in that graph, he write down that concept of medical, but it is not just for medical, because as you can see in Watson is not a medical device. So in AI healthcare, we can know that two kind of AI healthcare in Korea. So the first one is medical device, and second one is not medical device like Watson. Okay. So we should focus on these two type of medical two type of healthcare AI in Korea. So why do we know the healthcare AI? Because the first of all, growth of AI market in healthcare industry is quite good. So as you can see in this graph, the global AI healthcare market is expected to grow from about $500 million in 2013 to about 6.7 billion in 2021, sourced by Statista. And in Korea, in 2017, $94 million, but in 2025, $2 billion are expected. But as you can see in this argument, we do not have exact expectation in Korea because we have many regulations. So the government and many professors think that if the the height of the regulation is lower, then we can achieve the $2 billion in 2025. So it is kind of expectation, just expectation. So as you can see in this graph, we have many opportunity in healthcare AI, and before focusing on the regulation, we should define the type of data, because the healthcare AI is kind of using healthcare data. So healthcare data is key to AI used in the healthcare industry. So as I mentioned before, many people define the healthcare data, but no general discussion here. No general discussion exists. So I want to introduce many kind of classification in healthcare data. So the type 1 is the primary type. So first one is genetic information, as you know, and health information, and third one is electronic medical records, and the last one is national health information made by government. And the data type 2 is big data, paper data, and created by processing primary data. The primary data is type 1 I mentioned. And if so, I make some graph. I make some this kind of summary for many summary made by many professors. So we can classify this kind of healthcare data. So some people classify healthcare data like hospital solutions, personal healthcare, insurance, new drug development, and some other people classify prevention, diagnosis, treatment, management, something like that. So we, if we collaborate that kind of classification, then we can see this graph, the type 1, type 2, and prevention, diagnosis, treatment, management. But I want to get some doctor to this. So I should make some other new type of data. So I make some new data like data collection, data utilization, and data management. This is a kind of my concept of this healthcare data system. Okay, so I want to share 4 kind of case study. So in healthcare, AI healthcare. So this is as I mentioned before, we do not have the general concept of healthcare AI, but the government makes some license to company about AI healthcare. So this is kind of government's this is kind of products the government refer AI healthcare. So the first one is PUNO. So I think you already know the PUNO. So AI to help early screening for lung cancer by analyzing chest CT and solutions that let patients know 8 hours before cardiac arrest. So this is kind of they use the big data of chest CT, so they can predict more precisely comparing to other doctor. And this is kind of quite interesting in case, I think. The Privy is a smartphone AI automatically records and analyzes sound data that occurs when a patient's urine touches water. This is not a medical device, but as you can see in this graph, I think it is for just for men, but when men doing urine, they turn on this application, and the application records their urine sound and urine velocity and something like that. So they can record that kind of urine situation, and they make some process, they make some study about their urological situation. So by using this device, the doctor can easily diagnose and treat urological disease about the patient. So it is kind of quite interesting case. And also it is not a medical device. So Naked 3D fitness tracker is, it is quite interesting also. So AI measuring weight, visceral fat, and muscle mass for 25 seconds through products made by a large meters and turntable sets. So if you buy this application, then you can get some large meters and turntable sets. And using a large mirror and turntable, you can see your whole body like in 3D, and you can see your fatness, and you can see your body shape, something like that. So this application that have user goals and change their body shape. The last one is Exensia. So this is kind of the pharmacy company. So after setting the target, the long time it takes to enter the clinical trial is shortened to a short period of time by utilizing AI modeling. So as you know, when the pharmacy company want to make some new drug, they shoot many clinical trial like 3 or 4 times, and it takes a long time, about 10 years and more than 20 years, something like that. But by using AI system, they can reduce their long time to short time, like half of time comparing to past clinical trial. So it is kind of good case study in AI healthcare. Okay, so we can see the 4 kind of case study, and we can see another need for regulation. So I will compare domestic and foreign healthcare AI regulation. So start of domestic status, the Personal Information Protection Act, 개인정보보호법, provides a special provision for the processing of user information, 가명화 정보. So after revision, they make some follow measure. So the guideline for utilizing health and medical data are prepared. So it is kind of quite important guideline for AI healthcare. So the healthcare information, which is username, can be used for statistical writing and research purpose without the consent of the individual. It is purpose of username information. And however, there is a limitation in developing personalized healthcare and healthcare service, because unanimous data is greatly burdened. Furthermore, for personal information is currently regulated separately under the medical law. So it is, in short, even the revision of personal protection data law, we have another law about medical law, and another law like the Bioethics and Safety Act. So so what I want to say is we have many laws in healthcare AI. So revision of individual protection law, even if the government revise for using healthcare using the personal data to utilize many products, but we have another law like medical law and the Bioethics and Safety Act. So the AI healthcare cannot get their healthcare data easily. But in foreign status in US and EU, we can compare the US and EU. And US, information that is not identified, like I mentioned, 가명 정보, according to the non-identification guideline, like HIPAA, can be freely used without personal consent. And common law was revised in 2017 to simplify the creation of personal consent forms. So this kind of change means that the AI healthcare company can get easily from the individual. And in EU, also, as you know, EU has a quite a strict standard for personal data, but EU revised about personal data that the right of the subject of information are strengthened, but they make some right to data portability. So this is kind of the right of individual to force some institution to transfer their data to other institutions, something like that. So this is kind of a new right in EU. And in Finland, it is. I think I don't have enough. I don't have time, so I want to make sure. So in Finland, 2013 and 2019, they make some institution. One institution. They that collect the genetic data and health data and medical electronic data. So some company want to get some individual healthcare data, then they just request that institution for collection. So this is kind of good regulation. And Australia and Japan make some opt-out system that is quite good for a company, because the individual should some action for opt out their individual information. Okay, the second stage is the license process of AI medical device using healthcare data. So in domestic status, medical device AI takes hundreds of days to get on the market. So if you make some medical device in AI in Korea, then you prepare a long time to get a license. So the major step is 3-step. The Ministry of Food and Drug Safety, 식약처, and National Evidence-Based Healthcare Collaborating Agency, NECA, is 한국보건의료원, and Health Insurance Review and Assessment Service, that is 건강보험심사원. So as I mentioned, for making some medical device, we should get some license licensed by Ministry of Food and Drug Safety. And second of all, even we get some license for selling to a hospital and selling to a doctor, they said like that. We need some medical device protected by health insurance. So you should get some another license by NECA and Health Insurance Review and Assessment Service. So even medical device company can sell their product by after license of Ministry of Food and Drug Safety. The hospital and the institution of medical system want to get more license by National NECA and Insurance Review and Assessment Service. So they should get more license by 3 steps. But in foreign status, US, if included in Medicare convergence of innovative technology, like said MCIT, the automatic insurance payment system will apply. So if some company makes some MCIT, then they will go to another process about automatic insurance payment system. So they can easily sell to doctor about their products. And in Germany, they also make some similar system of US. So if the developed digital medical application empirically lacks evidence related to medical effects, even they do not have evidence related to medical effects, a test period is provided for 12 months and they get insurance. The last step is responsibility of AI healthcare using healthcare data. So domestic status, the government will review the amendment of Civil Act by 2023 to allow the right to remedy damages and crimes incurred by AI. So this is kind of interesting topic because we don't have any standard, we don't have any law of this kind of remedy damages by AI. So many professors said it is quite good for recognizing the right of AI in the current civil law, and it is, but there is a criticism of this revision because the AI doesn't have the object of rights. And in foreign status, EU advised that AI should be applied to the AI law if it causes damage to life, health, and or if it is directly linked to a verifiable economic loss. So I think EU is the first member for making this kind of standard and this kind of guideline for remedy of AI damages. So the aim of this is to ensure that we are liable for strict damages. So the implication for this comparing, so we get we get three kind of implications. So the first one is the need for integrated healthcare data management. So in Korea, we need integration of healthcare data management centered on institution like Finland. So as I mentioned before, we have many kind of regulation law like individual protection law and bioethics law and medical law. So many law regulate this healthcare data. So if some company want to make some products, they should proceed by those regulations. So like Finland, we make one institution to collect all healthcare data for the company. And the second one is extension of license for medical devices using healthcare data. So as I mentioned before, we have many kind of we have long time to get a license because of insurance system, but like Germany, we can apply some kind of temporarily insurance system. So if some medical device has doesn't have enough medical effect, but they have a potential, then like Germany system, we give them about 12 months or 18 months about insurance. Then I think the healthcare AI company get some money from them, and they proceed their development more, and they will easily probe their medical effects of their products. And lastly, the responsibility of AI using healthcare data. So reference to US case, we can make some guideline to remedy. So we just depends on the course decision, and it is kind of non-expectation for the company. So it is quite bad for that company and the industry. So we should make some guideline and some standard and make some law for remedy. Okay, so that's my speak overall. So thank you for listening this speak. So yeah.
So thank you, Boyoung Lee, for your kind of so very organized presentations, and I hope that this was great help to the students for preparing their studies.
Thank you.
So based upon this information and summary on healthcare issues in Korea and globally, so you can feel free to give your questions or ideas. So Boyoung, can you close your sharing the
Sure. I close my sharing.
Okay, good. So students can raise your questions. So of course, about the presentations, but also, yeah, the general topics of these lectures or the previous topic dealt with by me in the previous class.
Karim has a question, I
Yeah.
believe.
Yeah, sure.
First, I'd like to thank Bohyung for the interesting lecture. But I had a
Yeah.
more pragmatic question about our project. So when we're looking at our AI company, it's based in the US, but then when we're conducting our research, we're kind of judging it based on the European framework, right? And even inside the US, because it's a state, like it's divided into states, so each commonwealth has its own set of regulations and laws. In our case, the company in their legal like liability part, they say that they abide by the Massachusetts Commonwealth law when it comes to privacy and these kind of problems. So my question was, is there any kind of tips that you can give to non-law people on how to tackle the problem of understanding what the law covers and what it doesn't cover? Because for me, when I tried to read the law in Massachusetts, it was the legalese was kind of hard for me to understand. And I wasn't sure whether some cases that we're trying to judge would be covered or not. So maybe if you go back to the beginning of your studies, how did you tackle this problem of understanding this maybe difficult information?
Yeah, so I think you give me a difficult question, and I think that is kind of wonderful question. So yeah, as you mentioned, we cannot expect the judge's decision, and we cannot find the exact guideline for expectation about that kind of tackle. But as Professor He lecture, the last lecture, the Professor He said that many courts will compare their standard for compare the EU system or other foreign system to make judge. So I think I'm not sure I will give you the proper answer, but I think you can refer on another many kind of standard in the world. So as you mentioned, the MIT Massachusetts case, you mean?
So the company is located in Cambridge, Massachusetts.
Yeah.
So officially they're abiding by the laws of Massachusetts area, like the state of Massachusetts. But again, the problem is that the state of Massachusetts doesn't really have extensive guideline on privacy and consumer rights protection.
Yeah,
right now they have very like simplistic guideline, and they were planning on passing more involved guidelines that's more maybe similar to the European one.
Yeah,
but
right.
They didn't pass it. So my question was, in the case of the European case, or maybe even California, the way the law is defined is very clear on what should be covered and what should be protected. But in the case of the Massachusetts law, it's not that clear. It just says that
Yeah.
companies are liable for some cases, but then they don't really go into detail how these cases would work out. So my question was, how do you abstract or extract like useful information out of this very legalese? Like the way it's written is very in Korean, emehe, like not that clear, to be honest.
So,
Yeah.
I'm sorry, I forgot the word in English.
Yeah, so let me hijack Karim's good questions. Yeah, as I mentioned in the previous lecture, so United States started from, how to say, common law state, which is quite different from European civil law system. And common law system is basically following the power of president and principles in the collections of many cases, right? And as you know, so from the founding stage, so the United States were firmly, how to say, self-determined to respect the authority of each state, right? So the power of the federal government were highly restricted in the first age. So at the first beginning, so the power of federal government was strictly restricted to, for example, kind of foreign policy or proclaiming war against another country, or very restrictively kind of ICC issues, kind of interstate commercial clause. So when like kind of the size of railroad or something like that, so there should be, how to say, unified across the state. So all other kind of basic issues are retained. The authority of basic legal authorities were retained to each state. So I can say that was the story until kind of 1930s, before the Great Depression or so-called Roosevelt New Deal policy. So I can say that after the New Deal era, so the power and authority of the federal government has been, yeah, enlarged quite rapidly. So this was done by this way, kind of making special agencies, for example, FCC or SEC or something like that. So some agencies dealing with, how to say, federal general issues in government. So with that authority given to agencies, and there follows some special legislation, so which is giving that authority to that agency, and kind of many other articles prescribing the scope of that power on and authority of federal government. So that's kind of the situation up until now. So I can, in that sense, the US system is now kind of hybrid between the common law state and kind of civil law federal legislation issue. So in that sense, for Khalil to understand find out answers to your research, for example, in Massachusetts issues. So you should follow the Massachusetts State Act and legislations and cases that within that state court. But if you find that that issue is related to federal issues relating to other state or something like that, so you need to follow, you need to check whether there's some special federal level legislations or federal court cases. So that is the basic, how to say, track way. So for example, so in healthcare issues, so you should follow HIPAA, the Health Insurance or something like that, very long name. So or Consumer Protection Act, which is also governing the federal issues in how to say, privacy protection issues. So that is the how to say, very simple version of explanation to your questions, but in detail. So as you can imagine, it's not easy. So this is how the lawyers in United States get their money and live happy life, and why the law school system is prospering up until now. But I can say this is the basic summary of to your question. So I hope this was.
I think you've raised a very important point of trying to track lawsuits that are in the same jurisdiction and seeing how these worked out and maybe using them as a model, because I didn't really think about looking at lawsuits in maybe the state of Massachusetts that are related somehow to this area. If there is a similar lawsuit, then I think it would offer some sort of insight into how this law specifically works, right? So I thank you for this useful advice. I'm trying to do
this. Yes. This is basically data issues, law and case data issues. And US has, from very early times, developed their own, how to say, searching and database-based system for legal information. So for example, US law. Maybe some of you heard about that, or Hain Online. So this is filled with huge data on state level case, this court decisions, or federal level court decisions, or state legislation or federal legislations. And for the law school period, students learn so how to use this system. So yeah, they devote quite long time to learn the skill for searching. So quite good questions. And anybody else?
Soyeon Kim, is raising your hand.
Great. Thank you for your helpful presentation. And actually, when you asked the question before your presentation, I actually did not understand what your question meant. So I said the things off the top of my head. And after your presentation, I found that your question was about the data problem. And
Yeah.
when we deal with those AI system or AI devices, it's all about the data. So that was one of the things I got from your presentation. And my question is about the responsibility, because at the last part of your presentation, there was an issue of responsibility. Because last year I tried to write about the liability regime when people deal with those AI devices or problems, like I was really interested in and still interested in the self-driving cars. And as the professor Ha told us last time, which liability regimes we need to take into our society will be one of the key issues of the development of those AI systems or the AI devices. And it sounds like the revision that EU had done for its regulation was that it tried to the EU regulation or the regulators tried to grant personalhood to AI or something like that. Is it what happens in Europe right now? Is that they try to put some responsibilities and some rights on AI, but then there was an object that it's just it is not a human being or it's not an animal or something like that, that it can't have any liability regimes. I mean liability. So I was wondering what those EU regulators were trying to do. And also I have questioned that if this is what this world is going to be, then which one would be the proper liability regime for now and for the future? Like for example, when I was searching for liability regimes for self-driving car, there were people who say that, hey, we need to go back to negligence and fault system. And there were people, no, we still need to apply strict liability, but we need to revise the form of the liability regimes into like vicarious liability and stuff like that. So I was wondering what would be the most appropriate one for us in terms of healthcare.
So you give me two kind of question, right? The first one is the EU's regulation recently revision is what is the regulator purpose, and the second one is what I think the proper way to revise or make some guideline about liability in AI healthcare, right? Okay. As I mentioned before about EU revision, it is just for not just for AI, right? AI itself. It is for the people who make AI project. So I think I should research something more like that kind of revision. But I just want to focus on the people who make AI medical device should be should have, as I mentioned before, if someone make the regulation strictly, then the AI product and digital healthcare product cannot make their own project well, and this is kind of a huge problem because the industry of AI healthcare increase gradually, but some EU makes some strict rule, then they cannot grow. The many companies in EU cannot grow in because of that rule. So I think EU revised just for the people who make AI medical device, and they just narrow their responsibility for the, as I mentioned before, verifiable economic loss. So verifiable is quite important words in this revision, I think, in this regulation, I think, because many people who get lost from AI, who get damaged from AI device or AI healthcare device cannot easily prove their damage and cannot prove their damage is verifiably. So it is kind of the proper way between the right of the company and the right of the individual. And it is not a strict rule. It is just for proposed to EU members some guideline in also EU. So so the first question of yours is, I think, just focusing on the people who make AI device. And second of all, second of your question, I think it is quite a tough question, and I think it is a great question, because we have to consider the two kind of rights, because as you mentioned before, some people who got cure or treatment by AI medical device or AI non-medical device are wearing that the safety. So we should aware of their safety right. And in other side, the product of AI medical device have a right to make their own products and right to make economic benefits from them. So we have two kinds of rights collision in this situation. So we have to consider not just for protecting the individual's right, but also the right of the product manager, product company, something like that. So as you mentioned before, we should find the proper way of liability, but starting of making liability, I think we should make primarily change of collection of the healthcare data. So as I mentioned in step two, we should change our institution for one institution collecting the healthcare data, and that makes the individual's right protection, individuals information right more I think more protecting, and the company which want to make their product by their healthcare data collect well easily by just one request to that institution. So after change that kind of policy, I think after that we should make the responsibility or liability regime in AI healthcare, I think. So I think the government said that we should consider revision of Civil Act by 2023. That means they will change the institution of the collection data system. So yeah, that's my answer.
Okay,
Is it enough for you? Your
yes,
question?
I'm very much impressed for your wonderful questions and good answers. So let me add some remark. So maybe about the first question. So I understand it's about whether the AI program or AI system itself can be understood as kind of legal identity or legal personality, so on which civil liability or criminal liability could be levied upon. So is it true? So if I'm correct understanding on that topic, yes, that is quite hot topics nowadays going on around AI discussions, and there are quite strong argument and discussions that AI system itself should be given, how to say, legal identity as a person. So for which liability should be levied upon. As of now, including Korea, so many advanced legal system is taking that the legal identity as a person is given to two kinds of person. So the first one is so-called natural person or natural human being. So the another one is how to say a legal person, so called including 법인 or so for example, company is kind of legally assumed person in which kind of liability can levied upon. So and as you mentioned, like self-driving system or AI-based healthcare system. So generally, it will give one better or right answer than human beings, like human doctor. But you know, in a in so there should be some failure, which can bring about it damages to the people. So in that situation, so who should be the final, how to say, liability taker? So is it AI system itself or the human being behind them? So who programmed, who coded that system, or some guy who did the data feeding, so in kind of machine learning system. So this is quite interesting topic, but yeah, my guess is as long as maybe up until next one century, so that case of change will not happen because it is not very easy for so in a how to say mental experimental way. It is quite interesting topic, but it is not easy how AI system as a legal person can have their own asset, so on which damages liability can be kind of claimed against, or how AI system can be jailed upon, and how he can be forced to work for their not paying for their penalty or something like this. So this is quite too huge story to happen. So up until that Terminator world maybe next century. And about the second question, so I guess it's about how to develop, how to devise kind of most efficient liability system, kind of fault-based system. So we easily say, so nowadays the tort law, including Korea and many other advanced countries, are taking the negligence rule. So which means that there is some legal standard upon which the human beings should follow or maintain their caution level. So when they pay enough caution above that legal obligations, so they are exempt from all kinds of legal obligations. They are free to do whatever do. But when they do not pay enough attentions or they pay less caution than the legal standard, then legally, so they are understood as negligent or they are at fault, and they can be kind of under legal liability issues. And this this liability of negligence rule can be also kind of classified from like strict liability rule to no liability rule and some negligence rule in between. And so this is the basic framework of fault-based negligence rule we are taking. And the final choice for which legal system to consider is what is the most efficient or what is the most optimized legal system through which to induce each player's caution level to be optimum level. So through which to achieve the maximum social welfare of our system. So you can imagine the kind of driving kind of speed limit or something like that. So some legal system can be leading to social optimum, but some legal system can be understood as too strict or too harsh for the drivers, which can lead to inefficient or something like that. So you can imagine something like 민식이법 or something like that. So of course, people can have different ideas on these issues. So you can lead this idea to self-driving system and also the algorithm of AI. So I hope this helped a little bit to your questions.
Thank you for your answer. Actually, consumer protection and product liability, those are big issues in consumer science. So I was always curious about it. So I really appreciate your answer. Thank you.
Yes, maybe then you know that in consumer protection field, so the legal framework is taking so-called strict liability rule.
Could you try?
The strict liability rule. So the reason why that is taken is that under the standard negligence rule, the protection of consumer is systemically underprotected. So to cure that failure, the legal system has advanced to take more strict liability rule. So you can find similar situation in other risk situations for like nuclear liability or some product liability field or something like that.
Thank you.
Okay, so maybe we can move on to maybe another one or two questions.
Soyeon, you can speak up.
Thank you for your great presentation, and it was very helpful. And I recently read an article about how Facebook AI helps suicide prevention, and like social media platforms such as like Facebook, Instagram use AI to store and act on users' mental health data with no legal like agreement. And like some aspect it will help to like prepare some bad things in advance, but many users don't know how their data used and collected through the SNS, and like they don't just like store typical consumer data. And I think big tech companies must provide users like how they collect their data and how they use, and like I think they must have the the users must have the option to decline like consent. So I was curious about, is there any ongoing discussion about like big tech companies use the users' data and how they analyze and how they predict individuals' health data? So yeah, I just wanted to ask about that.
Okay. Thank you for your wonderful question. And it is kind of the problem of individuals' right. So even the big company makes some huge progress of healthcare sector, but even they violate the individual's right of healthcare. It is quite a problem, right? I understand your opinion, and about this, I heard that we many argument about should we make some system of opt-in or opt-out system. So if, as I mentioned about the foreign status, many Japan or Australia make opt-out system of healthcare data collection. So if individual want to get out that kind of data from that kind of data, they should say that I don't want to share my healthcare data to company. That is kind of opt-out system. But in Korea, we don't have the opt-out system. We just opt-in system. So if the company want to get healthcare data, then we should they should written consent or another kind of consent from the individual. But after revision of protection individual protection law, if the company get some healthcare or insurance data from some medical institution or some institution by anonymously, something like that, then they can get easily, because it is not a violation of individuals' right in Korea. So as your for your question, we have many study about opt-in system is good or opt-out system is good. So like you're saying, the problem of the big companies collection is kind of opt-out system. So, but in Korea, we don't have the opt-out system. So and right now, I think we feel relief. But as I mentioned before, the anonymous of individual data is kind of the opt-out system. So we should prepare, or we should talk about that kind of topic later on. So thank you for your question.
So yeah, another good question and good answers. Let me again, I'm sorry for too frequent hijacking, but yeah, I hope this helped your studying. So yeah, so we can say that data protection issues, including big tech company, is the main issues of privacy or protection of personal information. So we already know, you learned that it's based upon kind of the definition of personal information, so which is mainly following so-called identifiability aspect of that information. So for example, social security number or your birth date or something like that. This kind of, so nowadays with the development of technology, like the data of your locations, or when using your kind of T-map system or something like that, this can be also included as your personal information. And for some company, including big tech company, to collect that information and utilize, so they need to have your prior consent. And without that, so they can be, how to say, yeah, penalized, kind of, according to each legal system. So that is the basic system, the definition of personal information. And to sophisticate that definition, so we had the revision of Protection Act, and we introduced so-called private information and pseudonymized information, or so what is 익명정보?
anonymous information.
Anonymized information also. We have that kind of categorization according to which so we can treat differently. And so once it is understood as personal information, so we follow so-called opt-in way of protection. So they need prior consent. But you know, the reality of that is quite different. So how many of you have already fully read that kind of agreement when joining the Facebook system or when opening new iPhone opening new Apple ID? So do you know so how much that agreement when printed in A4 page? So can you guess how many pages that document are? So some professor in Chicago Law School, yeah, so printed that agreement in full material. It has been already 6 years ago. So he exaggerated somewhat, but he said that document can already fill up your room. So it's hard to say. It's not easy, of course, read from page to page and think about what this means, and after that you can decide whether to consent or not. This kind of opt-in is too much ideal. It's not real, something real. So you know, so to use some service provided big tech, so actually you don't have any choice to opt in or not. So this is kind of the system. So with that consideration, so nowadays there's some discussions going on. So how to rationalize or optimize that so-called opt-in, or how to sophisticate the meaning of consent, or how to redefine or sophisticatedly so the personal information. So you Soyoung made an example of like by using how to say photo informations, or like Zoom service may analyze kind of students' expressions or their gestures, and maybe they can analyze how's the mental status of the students, or how whether some users is okay or not. So in a good aspect, with that analyzing, so they can say that they can prevent maybe suicide or something like that kind of bad event. Or so we can easily imagine that the technique can be, how to say, used in a very bad way, or to, as we already know, the kind of Facebook information can be misused for like kind of election campaign purpose or something like that. So this is the ongoing issues. And you know, the legal system and law, so there are many quite bright lawyers, actually too many lawyers in Korea and United States. But you know, the history is saying that the legal system is always behind the social change, especially if it is the kind of technological development maintained by big tech companies. So we all share the problematic situations and issues, especially from the legal aspect. But so we are trying, but I should confess that the lawyers and legal system are always late for dealing with that kind of issues. But we also need to think about that, how much legal system can advance rapidly than the real society. And so they can kind of, if they can decide what is good or what is bad, or what is legal or what is illegal, before what things happens. So we should also think about that kind of world is the real world, what we want or not. So that is, yes, I can say that your question was wonderful, but the answer is still ongoing.
Thank you.
So yes, I can say that yeah, today's topic was also quite interesting and helped for your studying and your project. And I could see that wonderful Q&A and discussion sessions were following in that presentation. So with that, we can give big applause to today's speaker, Ho Young Lee, and wrap up this class.
It was an honor to speak. Thank you.
Okay, thank you everybody. And again, I hope you have wonderful evening and wonderful another week. So see you next Monday. So next week's topic will kind of AI decision making, so inside public field. For example, so the public agencies decision making through data or AI. So which I hope should be quite another interesting and important topic. So every guys, see you next week, Monday. 자, 이보영 수고 많았습니다.